Welcome to the deep dive, where the echoes come alive. With every word we'll navigate through the mysteries we create.
Imagine, if you will, sitting down to play like a really high-stakes game of cards. You've got your entire life savings pushed right into the center of the table.
Oh man, it's stressful.
Yeah, exactly. You are sweating. And the dealer looks you dead in the eye and explains the house rules. Your opponent gets to see every single card in your hand, but they are legally allowed to hide half of their own cards from you.
Right.
You can't see their discards, you can't see their tells. And if they happen to have a card that proves you actually won the hand, they can just, slip it into their pocket and pretend it doesn't even exist.
Wow.
So how exactly do you defend yourself if you literally do not know what you're up against?
I mean, it's a structural impossibility, right? The game is rigged from the literal moment you sit down.
Exactly.
You are operating in this vacuum of information while your opponent has total visibility. And yet we sort of rely on this assumption that in the real world, especially in a courtroom, that kind of asymmetry just doesn't exist. We want to believe the justice system is this level playing field where all the cards are face up.
Right. But that rigged game is the exact scenario at the heart of today's stack of documents. We've got trial transcripts, police emails, analytical memos, and legal briefs, and they're all charting the prosecution of a woman named Stephanie Larocque in Ottawa.
Yeah, it's a massive stack.
It is. And we're going to use these sources to understand this massive collision between mandated police protocols and, well, constitutional law.
It's a fascinating case study, because it really forces us to look at what happens when the machinery of the justice system, specifically the intimate partner violence or IPV framework, is activated, right? Designed to protect the vulnerable. But then imagine the lead detective just totally ignoring the instruction manual.
Right, yeah. It's wild to look at.
Yeah, so welcome to today's deep dive. We are zeroing in on a very specific case study today. We're looking at how mandatory intimate partner violence, or IPV protocols, actually function in reality, or, well, fail to function.
Exactly.
And for this, we're focusing exclusively on the actions of lead investigator Detective Jessica MacFadyen in the Stephanie Larocque case. So let's unpack this. How does a detective trigger an IPV investigation, but skip the actual investigation part?
Well, I mean, it happens when the system's administrative tools are fundamentally misused. Like when a file is officially flagged as IPV, it legally triggers mandatory protocols. Specifically, there's the ODARA.
Oh, right, the ODARA.
Yeah, it's the risk assessment tool they use to gauge a suspect's history of violence and, their current threat level. But Detective MacFadyen actually checked no for the ODARA and just left the score completely blank.
Okay, wait, I have to push back here for a second. Are we saying she intentionally bypassed the rules out of malice? Or, I mean, is it possible she just made a clerical error, like under the pressure of a massive police caseload, maybe?
That's a fair question. But what's fascinating here is the actual mechanics of how these investigations are processed. Leaving that score blank isn't just a typo. It's essentially a procedural override.
A procedural override? How so?
So by classifying the file as IPV, MacFadyen unlocked mandatory charging. That's a policy that removes an officer's discretion and literally forces them to lay charges if there are reasonable grounds.
Oh, okay.
Yeah. But by skipping the ODARA, she bypassed the mandatory safety checks designed to ensure she was actually targeting the primary aggressor. The software apparently just lacked a hard supervisory stop to prevent someone from triggering those charges without, doing the required assessment.
So the software basically allows you to pull the fire alarm without verifying if there's actually smoke.
Exactly, yeah.
That's crazy. And her entire investigation ended up being just a review of a 911 dispatch call, some basic police records, and unverified email screenshots provided by the complainant, Michael Broughton. I mean, it's like a doctor diagnosing a patient by only asking their ex what's wrong.
That is a great analogy. And that flawed diagnostic process directly influenced what happened next. Because she didn't conduct that initial risk assessment, MacFadyen. She actively rejected the accused evidence.
Right, because she sought an arrest warrant, officially claiming Stephanie Larocque was unreachable. Because the detective tried calling a disconnected phone number.
Right, a disconnected number.
But she wasn't unreachable at all. Larocque was actively emailing MacFadyen. She was literally sending over family court orders, pointing out the specific exceptions in a prior court mandate that legally allowed them to communicate, and she was offering to speak by phone.
Yeah, and this is where we see profound confirmation bias really take hold. MacFadyen just dismissed Larocque's evidence as rambling.
Rambling, wow.
She actually replied via email stating, "Well, I will not entertain this nonsense." And then she refused any further email correspondence.
The confirmation bias didn't just stop at ignoring her emails, though. I mean, it extended to ignoring her entire history in their own police database. MacFadyen completely overlooked a 2018 sexual assault file that Larocque had previously lodged against Broughton. She had the data right in front of her.
She really did. And that blind spot raises a critical issue about how investigative tunnels are formed,
Right.
Like when Larocque explicitly asked if Broughton would be held accountable if he was proven to be lying, MacFadyen immediately answered no.
Unbelievable.
The mechanism here is just administrative convenience. The investigation morphed from an actual inquiry into the facts, into the mere processing of a file based on a predetermined narrative.
So what does this all mean for you listening? Like, why should you care about one detective's paperwork shortcuts? Well, because when authorities prioritize administrative convenience over mandatory protocols, it instantly turns the justice system from a protective shield into a weapon.
Right. It clearly demonstrates that protocols only work if the people enforcing them are held to the same strict standards as the people they are investigating.
Exactly. And if police only require unverified screenshots from one party to issue an arrest warrant, it makes you wonder, is the legal system actually investigating a crime or simply acting as an administrative tool for an abuser's coercive control, for instance?
So, if we are looking at a system where the cards are supposedly being hidden, I think we have to start by understanding the rules of the game. Like, what is the legal bedrock here? If I am accused of a crime, what is the state legally required to show me before we even walk into a courtroom?
So to understand the gravity of this case, you have to understand a 1991 landmark Supreme Court of Canada decision. It's called R.V. Stinchcombe.
Stinchcombe.
Yep. Yeah. And this isn't just some minor procedural guideline, right? It is the absolute gravitational center of the Canadian criminal justice system. Stinchcombe basically dictates that the Crown, the prosecution, has a constitutional duty to disclose all relevant information to the defense.
All of it?
All of it. The prosecution cannot hold back evidence.
Wait, I just want to make sure I understand the scope of that. Does that mean, like, everything the police collect, even if it makes the prosecution's own case look incredibly weak?
Everything. Everything that is not protected by a very specific legal privilege. The ruling is actually derived from Section 7 of the Canadian Charter of Rights and Freedoms.
Which is the one about life, liberty, and security.
Exactly. Yeah. The guarantee to life, liberty, and security of the person. The Supreme Court recognized something super fundamental here. The fruits of a police investigation are not the private property of the prosecution to be used just to, win a conviction.
Right.
They are the property of the public, and that includes the accused person. The Crown is supposed to be interested in justice, not just securing convictions.
So if the police find a witness who says, "Hey, I saw the whole thing and the person you arrested didn't do it," the prosecutor can't just bury that witness statement because it ruins their case.
They absolutely cannot. That would be a massive failure to disclose exculpatory evidence.
Exculpatory?
Yeah, exculpatory simply means evidence that tends to clear a defendant of guilt. And here is the why behind this rule. When the state fails to provide a comprehensive evidentiary record, it creates this massive information asymmetry.
Like the card game.
Exactly like the card game. Think about it. The state has the police force, they have forensic labs, subpoena power, and virtually unlimited funding.
Right.
The accused has literally none of that. So if the state holds back evidence, they leave the accused totally guessing about the case they have to meet. You cannot make a full answer in defense, which is your constitutional right, if evidence that could clear your name is sitting in a police file cabinet somewhere, just gathering dust.
Which brings us to a really specific document in the Larocque case file. If you are listening and looking through the sources right now, you really need to check disclosure, starting with point 4.
Yes, point 4 is key.
It's this defense screening document where Stephanie Larocque explicitly outlines exactly what the Crown is legally obligated to hand over, but hasn't. And point 4 is the explicit demand for that exculpatory evidence you just mentioned.
And it is an incredibly granular demand, too. Point 4 asks for materials that negate guilt, corroborate lawful conduct, contradict the complainant's allegations, or indicate any procedural irregularities.
It's very thorough.
Very. But the document goes much deeper into the mechanics of the case as you keep reading.
Yeah, like point 5 demands Crown screening records, which are the internal analyses showing how the charges were even approved in the first place.
Right.
Then point 6 asks for family law orders. Point 7 asks for witness materials, specifically naming sworn affidavits from witnesses. I think the names were Jacob James Larocque and Douglas Lorne Cotty. And then point 9, and this seems like a major one, it demands lesions. Prior complaints and pattern evidence against the complainant, her ex-husband, Michael Broughton.
Yeah.
So the defense is literally telling the Crown, hey, we know there are previous complaints against this individual sitting in your own database. We need them.
And that's the thing. When a defense lays out a Stinchcomb demand with that level of specificity, it is not a blind fishing expedition. They aren't just guessing. They are pointing to known entities.
Right. They know it exists.
Exactly. For example, they point to an audio and video forensic brief, specifically a file named nothinglies.wave, which allegedly contains recorded admissions and evidence of digital tampering by the complainant.
Wow.
Yeah, they are pointing to metadata. They are pointing to a transcript of a 2019 foreclosure hearing. They are giving the Crown a highly specific, literal map of the missing evidence.
Let's actually pause on the metadata for a second, because if you're listening to this, you might be wondering why a digital file is so important. Like, if someone sends me a threatening text and I take a screenshot of it and show it to the police, isn't that proof? Why does the defense care so much about the metadata?
That is such a common misconception. A screenshot is fundamentally just a grid of pixels. It has no underlying truth to it. It is incredibly easy to alter.
Right. Anyone can do it.
Literally anyone. I could take a screenshot of a text conversation, drop it into Photoshop, change the words, change the timestamp, and save it as a new JPEG in about 3 minutes.
Yeah, I've seen fake text generators online that do it in 10 seconds.
Exactly. So the metadata, or the XIF data, the server logs, the hash values, that is the actual digital footprint of the file. It tells a forensic analyst when the file was truly created, what device it was created on, and most importantly, whether it has been altered since its creation. Without the metadata, a digital image is legally hollow.
And the sources state that the complainant, Michael Broughton, is a senior Oracle programmer with 25 years of IT experience.
Right.
He literally programs systems and databases for a living. So the defense is basically saying, you are accepting unverified images from an IT expert without pulling the digital footprint to see if he faked them.
And that is exactly why the constitutional requirement of full disclosure is so vital. But if we contrast that requirement with what the Crown actually provided to Larocque, the gap is just staggering.
It's wild.
The sources show the Crown provided a 3-line civilian will state document and the screenshots provided by Broughton.
3 lines. And just a few JPEGs.
That's it. They completely excluded the exculpatory audio files. They excluded the metadata that would prove whether or not the digital evidence had been tampered with. They excluded the sworn affidavits from witnesses. The defense document even notes that the police and the Crown categorized Larocque's submissions of this exculpatory evidence as, quote, rambling.
Wait, they just called her evidence rambling and refused to even look at it?
Apparently so.
There's literally an email in the file from the intimate partner violence mailbox where an officer notes that Larocque sent audio clips and a PDF alleging media manipulation, and the officer's internal note just says, no further action. They literally just wrote it off.
Just brushed it aside.
So if the law so strictly demands all this evidence be collected and handed over, the logical question is who decided not to collect it in the first place? How does an investigation develop such a massive, glaring blind spot?
Well, investigations don't spontaneously generate blind spots, right? Those blind spots are engineered by the choices of the people running the case. To understand how this happened, we have to look at the person who built this file from the ground up.
The lead investigator.
Yes. Detective Jessica MacFadyen of the Ottawa Police Service Intimate Partner Violence Unit.
Okay, before we dissect Detective MacFadyen's specific actions, I think we really need to understand the environment she operates in. Why does the IPV unit exist, and why does it have such extraordinary powers? Because the sources point back to a parliamentary debate, a Hansard record from 1982, where a member of parliament named Margaret Mitchell stood up to raise the issue of wife battering.
The historical context here is so crucial. In 1982, Margaret Mitchell cited a statistic in the House of Commons that 1 in 10 Canadian husbands beat their wives.
1 in 10.
Yes, and the response from her male colleagues in the chamber, It was laughter and heckling. They literally laughed at the concept of domestic violence.
That is just sickening to think about.
It is, but she pushed back. She stood there and stated it was no laughing matter. And that moment actually became a national catalyst. It forced the government to finally acknowledge that spousal abuse wasn't just some private family matter, it was a criminal offense. And this eventually led to the adoption of mandatory charging policies across Canada.
Right, and the intent behind that was to protect victims. Because prior to that, the police would show up to a domestic dispute, tell the husband to, take a walk around the block to cool off, and then leave the woman in the house in severe danger.
Exactly.
So mandatory charging policies were designed to take the burden off the victim. The police must lay charges if there are reasonable grounds, so the abuser can't just intimidate the victim into dropping the case later.
The intent was absolute protection. However, as the academic paper in our sources by Anita Grace points out, the paper is titled, "They Just Don't Care," these policies have developed complex, really unintended consequences.
How so?
Well, because the police are mandated to lay a charge when called to a domestic incident, they are required to identify the primary or dominant aggressor. But Grace's research shows that the system often fails to properly identify that primary aggressor.
Right.
Abusers learn how to weaponize the police. They make the first call. They present themselves as calm and collected to the officers, while the actual victim, who is traumatized, might appear frantic or erratic.
Oh.
Yeah. As a result, women who are the victims of ongoing abuse are sometimes inappropriately arrested and charged themselves. The framework designed to protect them is turned into a tool of their abuse.
Which brings us right back to Detective MacFadyen and her role in this specific case.
Mm-hmm.
She takes over the Larocque file, and we can actually see her exact investigative process because we have her own duty notes.
We do.
And this is where I'm completely stuck, because there's a glaring contradiction in those notes regarding something called the ODARA. Can you explain what that is and how it works?
Absolutely. The ODARA stands for the Ontario Domestic Assault Risk Assessment. It is a mandatory 13-item actuarial tool used by police in Ontario to assess the risk of future intimate partner violence.
It's basically a checklist.
It's essentially a checklist that calculates empirical risk, yeah. The police are required to look at the history of the relationship, prior court orders, substance abuse, and the relative vulnerability of both parties. It is the foundational step for identifying the primary aggressor and deciding just how aggressively the state needs to intervene.
Okay, so it's the instruction manual for the IPV framework. You have to use it to justify using the heavy machinery of the domestic violence unit.
Right.
But in the prosecution summary for this case, the field for the ODARA is literally checked no.
Right.
And the score field is left entirely blank.
Which creates an irresolvable logical paradox. Detective MacFadyen explicitly checked no, ostensibly declaring that the criteria for a high-risk IPV assault were not met. And yet, she simultaneously invoked the extraordinary coercive powers of the IPV framework to seek a woman for Larocque's arrest in the first instance.
That makes no sense.
It doesn't. You cannot logically declare on a mandatory risk assessment that a case doesn't meet the risk criteria and then use those very same IPD protocols to mandate a criminal charge and bypass normal procedures.
It's cognitive dissonance on an institutional level. How can a prosecutor even attempt to present a case built like that in front of a judge? By bypassing the ODARA, she bypassed the entire process of figuring out who the actual primary aggressor was in the first place.
Exactly. She made a unilateral decision to believe one party, Michael Broughton, without investigating the context of the other. When you look at her notes detailing what the investigation actually consisted of, it's incredibly thin.
Yeah, I was looking at that.
She notes that she reviewed the CAD call, which is just the 911 dispatch log. She checked CPIC, which is the police database. She read initial officer reports. And she looked at the unverified screenshots provided by Broughton.
And what did she ignore? She ignored the family court records, the outstanding custody orders, the documented history of noncompliance by Broughton. And perhaps most astonishingly, she ignored previous domestic violence complaints against Broughton that were sitting right there in her own police department's database.
It is the definition of selective enforcement.
Right.
And to understand how a system does this, we can look at an analogy used in the source material.
Oh, right, the librarian analogy. I love this one because it breaks down the systemic mechanism perfectly.
It really does.
It says, imagine a librarian tasked with archiving historical documents. But instead of reading the documents and organizing them objectively to figure out what happened, the librarian pre-writes the summary for the back cover of the book before they even open a single box.
Right.
Then they start going through the documents. Any paper they find that supports their pre-written story gets framed and put on the wall. But any document that contradicts their summary, they just throw it straight in the trash. The actual truth is treated as an inconvenience to the narrative they've already decided to publish.
That analogy perfectly illustrates confirmation bias operating as policy. When you predetermine the outcome, evidence ceases to be information. It just becomes an obstacle. And we see this active avoidance of information peak during a chilling email exchange between Detective MacFadyen and Stephanie Larocque on September 4, 2024.
Let's walk through that exchange because it's genuinely baffling.
Great.
So MacFadyen emails Larocque to inform her that she has grounds for her arrest and tells her to turn herself in. Larocque replies almost immediately. She says she is puzzled why they are reaching out now after years of the police allegedly ignoring the abuse she and her children endured. She's clearly distressed, but she is engaged. She is hitting replies.
She's communicating.
Exactly. So how does the detective respond to a suspect actively communicating with her?
MacFadyen's response is highly restrictive. She writes, and I'll quote it, "I am not going to correspond with you over email. If you would like to discuss any of your concerns with me, then please call the extension I provided. If you fail to do so, then I will be issuing a warrant for your arrest."
Wait, how does an investigator physically declare someone unreachable and get an arrest warrant when they're actively responding to an email thread? Like, what is the actual legal mechanism there?
Well, the legal mechanism for a warrant in the first instance is supposed to be a measure of last resort. A justice of the peace issues it when a suspect is actively fleeing the jurisdiction, hiding from police, or poses an immediate threat to the public, meaning a simple summons to appear in court just wouldn't suffice.
You're right, if they're on the run.
Exactly. Seeking a warrant on the premise that a suspect is unreachable while simultaneously corresponding with them via email is a contradiction in terms. The analytical memo in the sources suggests this warrant wasn't a tool to secure attendance in court at all.
What was it then?
It was used as a punitive measure. The process itself became the punishment.
And the charges they were threatening her with are just as confusing. We have to talk about the dog emoji. Larocque is actually charged with break and enter and theft. For what? For retrieving a dog.
And not just any dog. The file indicates that Larocque possessed certified registration records proving her legal ownership of the dog since 2018 under the Ontario Dog Owners Liability Act.
I want to slow down on that.
Yeah.
Because the Dog Owners Liability Act isn't just a suggestion, right? It's the civil law regarding property and responsibility.
Yeah.
If the dog bites someone, the registered owner is legally on the hook.
Exactly. The Act clearly states that legal responsibility and ownership rest with the registered owner. Michael Broughton, according to the documents, had absolutely no legal standing regarding the dog under that act.
Right.
Yet, Broughton calls the police, claims she stole the dog, and the police treat his claim as absolute truth. Sufficient to lay criminal charges, they completely ignore Larocque's documented, verified legal evidence of ownership.
They allowed an IPV complaint to completely override civil property law without even verifying the registration. It's like someone calling the cops to say I stole their car, and the cops arresting me even while I'm holding the registered title in my name just because the other guy called first.
It demonstrates a total inversion of investigative standards. And this is exactly the institutional betrayal that Anita Grace writes about. The system is no longer functioning as an impartial arbiter of facts. It is functioning as a blunt instrument directed by whoever controls the narrative first.
So we have an investigation built on unverified screenshots, explicitly ignoring mandatory risk assessments like the ODERA, ignoring exculpatory evidence, ignoring civil property law, and resulting in an arrest warrant based on the completely false premise of an unreachable suspect.
Yeah, that's the foundation.
If you're listening to this right now, you're probably thinking, there is no way a prosecutor takes this to trial. The second a judge sees this, the case gets thrown out. Because the system has checks and balances for a reason. The trial is supposed to be the crucible where these failures burn away.
You would expect that. But when we look at the trial transcripts from April and May of 2026, we see a legal strategy employed by the Crown designed specifically to prevent that crucible from ever getting hot. They employ a strategy of insulation.
Let's set the scene for this trial then. The Crown is trying to secure a criminal conviction that could severely impact Stephanie Larocque's life. They carry the burden of proof. They have to prove their case beyond a reasonable doubt. So who do they call to the witness stand to build this case?
They call exactly one witness.
One.
The complainant, Michael Broughton. And then the Crown rests its case.
Just the ex-husband, no forensics experts to talk about the emails, no independent witnesses, and most shockingly, no police officers.
None.
The transcripts highlight an absolute elephant in the room here. Detective Jessica MacFadyen is physically sitting in the courtroom. She is identified on the record as the officer in charge. She's sitting right there next to the Crown prosecutor every single day of the trial. But she never takes the witness stand.
In a normal context, this is an unthinkable legal strategy. Think about the nature of this case. It is built almost entirely on digital evidence, alleged emails, and digital breaches of a peace bond. In any standard criminal trial involving digital evidence, the investigating officer is the foundational pillar of the prosecution's case.
But why wouldn't they just put the officer on the stand to confirm she collected the emails? Why hide your lead investigator?
Because of a concept called the chain of custody. If the Crown submits a printout of an email, the judge can't just assume it's real. The police officer has to take the stand and testify, I seized this phone, I downloaded this database, I verified the server logs, and I can confirm this image is an authentic representation of the data.
Okay, that makes sense.
The officer authenticates the evidence. By not calling Detective MacFadyen to the stand, the Crown intentionally freezes the record.
Freezes the record. It's like playing a game of chess where you legally submit your pieces to the board. You can't make any new offensive moves, but it guarantees your opponent can never knock your king over.
That is a perfect analogy. The Crown submitted the screenshots provided by the complainant without any police testimony to back up how they were verified. And they do this because if MacFadyen takes the stand, she becomes subject to cross-examination.
Right.
Stephanie Larocque was representing herself. If the detective testifies, Larocque has the constitutional right to ask her questions under oath.
Oh man, imagine what that cross-examination would have looked like. Laura could have handed her the prosecution summary and asked, Detective MacFadyen, why did you check no on the mandatory ODARA risk assessment, but still use IPV powers to arrest me?
Exactly. She could have asked, why did you categorize the video confessions I sent you as rambling without watching them? She could have asked, why did you accept easily manipulated JPEGs as proof of a crime instead of pulling the original server logs, especially knowing the complainant is an IT expert?
By keeping the detective off the stand, the Crown ensures that Larocque can never ask those questions in front of the judge. The Crown shields the police from having to answer for the missing investigation. It is a brilliant, albeit terrifying, tactical maneuver.
It's a maneuver designed to control the narrative by severely restricting the flow of information. But Larocque refuses to let that silence stand. She realizes exactly what the Crown is doing, and it leads to a profound showdown with the trial judge, Justice Berg.
Yeah.
Which brings us to the most intense part of these sources, Larocque's real-time indictment of the players on the official court record.
The transcripts from this trial are genuinely difficult to read. You expect a courtroom to be a place of decorum and, basic procedural fairness. But let's look at the transcript from April 24, 2026. Larocque arrives late to court. But she isn't late because she hit traffic. She is experiencing a severe medical emergency.
A very severe one.
She has stage 5 COPD and is having an asthma attack that required her to retrieve her Ventolin inhaler. She can barely breathe.
And instead of accommodating a disabled litigant, Justice Berg displays open hostility. The transcript records him saying, I think we bow to the inevitable. At this point, she appears to be in distress, but she still has to be present. Can you concentrate now, or are you in distress?
Wait, doesn't a judge have a legal duty to accommodate someone?
But the judge's reaction here suggests that the pre-written story, from our librarian analogy, the narrative that Larocque is unstable, manipulative, or evasive, has already tainted the court's perception. Every gasp for air is viewed not as a medical crisis, but as a deliberate obstruction of justice.
But Larocque doesn't fold. She is struggling to breathe, but she fights back using the system's own language. She uses the court transcript to build her appeal in real time. She looks at the judge and says, he knows the law and he's not following the law. I would like for that to go on the record for appeal purposes.
It's powerful.
She is explicitly indicting the players while the game is still being played.
It is a remarkable display of legal self-advocacy. She demonstrates a grasp of Supreme Court jurisprudence that many law students struggle with. She explicitly names the case law the system is violating. She cites R.V. Jordan.
Let's break these down, actually, because she isn't just throwing out random names. What is Jordan?
R.V. Jordan is a Supreme Court case that established a strict mathematical ceiling for how long a criminal trial can take, usually 18 or 30 months, depending on the court. If the state delays the trial beyond that ceiling, it violates the charter right to be tried within a reasonable time, and the charges must be stayed. She is putting on the record that the Crown is dragging this out.
Wow. And then she cites R.V. Babos.
Babos deals with the doctrine of abuse of process. It asks whether the state's conduct is so oppressive or so compromises the fairness of the trial that it shocks the conscience of the community.
Well, I see.
She is arguing that ignoring her evidence and threatening her with arrest while she emails them meets that threshold.
She also cites R.V. Antic.
Antic reformed the bail system in Canada, establishing the latter principle, which says the state should use the least restrictive conditions possible to ensure a person attends court. She is arguing her conditions were excessively punitive.
And of course, she cites Stinchcombe and McNeil regarding the Crown's failure to disclose evidence and third-party records. She is a self-represented litigant, doing the work of a seasoned defense attorney while actively having a medical emergency.
It's unbelievable.
But despite her legal knowledge, she runs headfirst into a procedural brick wall on April 30th, 2026. This is the absolute catch-22 of the entire case.
It is a perfect closed loop of institutional logic. On April 30th, Larocque tells Justice Berg that she intends to bring up the missing O'Dara assessment and Detective MacFadyen's unfulfilled investigative duties in her closing arguments. She wants to argue to the judge that the police failed to do their basic job, which creates reasonable doubt.
And Justice Berg replies, and this is a direct quote from the transcript, "If it is not before me, it is not evidence. I never see disclosure."
Let's unpack the mechanics of why that ruling is so devastating. Larocque wants to talk about the exculpatory evidence, the missing O'Dara, the ignored videos, the metadata. But Justice Berg is telling her she cannot mention it in her closing arguments because that evidence was never formally entered into the trial record during the evidentiary phase.
But it wasn't entered into the trial record because the Crown withheld it from the disclosure. She couldn't enter it. And even the parts she did know about, she couldn't enter into the record because the Crown intentionally kept Detective MacFadyen off the witness stand, meaning Larocque had no one to cross-examine to introduce those facts.
Exactly. She realizes the trap has snapped shut. The system successfully suppressed the truth using its own procedural rules.
It's maddening.
The Crown hides the evidence. The Crown refuses to call the witness who collected the evidence, and then the judge says, well, since no one brought up the evidence during the trial, you aren't allowed to talk about it now. It is a flawlessly engineered mechanism for ignoring reality.
Larocque literally says to the judge in frustration, "Oh, so what is the point of the disclosure then? So they only withheld it from me, not you." And the judge just repeats, "I never see anything." It's infuriating. The rules meant to ensure a fair trial, rules about only judging what is on the official record, are being weaponized as a procedural gag order.
If we connect this back to the bigger picture, this brings us full circle to the Anita Grace academic paper about women charged with domestic violence in Ottawa. This trial is the exact mechanism of institutional betrayal that Grace's research identifies.
Right, the paper we mentioned earlier.
Yes. When women who are victims of abuse are inappropriately charged because the police failed to conduct a primary aggressor assessment, the trauma is profoundly compounded by the justice system itself.
The paper notes that women experience these failures by police and courts as a deep betrayal, to the point where they feel the state becomes complicit in their ongoing abuse. The system that was built to protect them. Remember Margaret Mitchell in 1982 fighting the laughter in the House of Commons to mandate these protections. That very system becomes a weapon used by their abuser to silence them.
It's tragic.
As a result, the paper concludes, these women vow they will never turn to the police for protection again.
And can you blame them? If you provide the police with forensic audio files, metadata, and civil court orders, and they refuse to look at it, call your evidence rambling, bypass mandatory risk assessments, and charge you with a crime based on unverified JPEGs from your abuser, why would you ever trust that institution again?
You wouldn't.
This kind of systemic failure doesn't just harm Stephanie Larocque. It erodes public trust in the administration of justice entirely.
Okay, let's pull all of this together, because we have covered an immense amount of ground today. We started by looking at the highest constitutional promise of the Canadian justice system, the promise of full disclosure under Stinchcombe, the promise that the state won't hide its cards, and that you will have a fair chance to defend yourself against the massive power of the government.
We then saw how that promise fractured on the ground level. We examined how a lead detective, Jessica MacFadyen, bypassed mandatory IPV protocols, specifically the O'Dara risk assessment, to utilize the coercive powers of the charging system without conducting a foundational objective investigation. We saw how evidence was ignored to preserve a pre-written narrative.
We witnessed the legal sleight of hand in the courtroom, The strategic decision to keep the investigating officer off the witness stand, perfectly freezing the record and shielding the police from having to answer for their blind spots.
Yeah.
And finally, we read the desperate, brilliant, real-time indictment of a self-represented woman fighting through a medical emergency to name the exact laws a hostile system was violating in order to ignore her.
It is a stark reminder that constitutional laws and police protocols are only as good as the individuals entrusted to apply them. When the culture of an institution prioritizes processing a file or winning a conviction over investigating the objective truth, the procedural safeguards become entirely meaningless.
Which leaves us with a final, slightly terrifying thought for you to chew on. We live in a world where digital manipulation is easier than it has ever been in human history. A tech expert, or honestly, anyone with a smartphone and 5 spare minutes can alter a text message, change an email date, spoof a sender address, or doctor an audio file.
Very easily.
What happens to the integrity of our justice system if police and courts decide that a simple, unverified screenshot is enough to secure an arrest warrant? If the police officers who collect that digital evidence are strategically shielded from taking the witness stand, and judges refuse to look at the metadata because of procedural loopholes, how do we ever truly prove reasonable doubt?
It's a scary thought.
The next time you send a quick text or an email, ask yourself if someone manipulated that digital footprint to frame you. Would the system even allow you to prove it?